Good afternoon and welcome everyone to Surrey Law Society's Managing Family Dynamics in the Probate Process with Gareth Ledsham. My name is Kieran Bow. I am a private client practitioner and Honorary Secretary of the Surrey Law Society. Just to briefly advise us to some upcoming events and CPD with Surrey Law Society. We have a webinar very shortly on the 14th of June, maximising income and increasing profit margins and practical points for fee earners in an inflationary environment. I think that's something that's going to be pressing for many firms and practitioners alike. One of my favourite events in the year, the Past Presidents Championship Cup, karting event at Esher, really well attended and great fun, and that's on the afternoon and evening of the 15th of June. And further private client course also in June, use of wills, trusts and variations for IHT planning in a tax environment. The full programme of CPD and events is of course available at our website, surreylawsociety.org.uk. In terms of housekeeping this afternoon, if you have a question, you can use the Q&A function with Zoom, and if you would like to have put a question to Gareth at the end of the webinar, by all means use the raise hand function as well. I throughout the webinar will keep an eye open for the chat box as well for any questions. Just to advise, this webinar is recorded and the recording will be sent to all participants shortly after the end of the webinar and certainly later this week. It's my great pleasure that we are supported today by Finders International and who have been supporting Surrey Law Society for a number of years. And Louise, if I can introduce you and ask you so we can learn a little bit more about Finders International. Thank you, Louise.
Thank you very much. Just checking that you can hear me all right. I'm just going to take a few minutes today. So my name is Louise Levine. I'm the International Asset Services Manager at Finders, and we're very proud sponsors today and very much hope you enjoy the webinar. Just going to take a few minutes, kind of refresh your knowledge of the breadth of services and support services that we're able to offer practitioners. Firstly, we've grown quite a lot in recent years. We're now over 80 strong. We have offices in London, Edinburgh, and Dublin. We've got a network of agents and partners all over the world. So we're well placed to meet your needs. We work primarily for legal professionals, but we can also work directly with executors where needed. We work with local authorities, deputyship teams, and coroners. We work on thousands of cases every year. We take a dynamic and friendly and professional approach to our work. We're perhaps best known for tracing heirs and for reconstruction of family trees, but we have a lot of other services that might be of interest. So we don't just trace, for example, heirs in large intestacies where nobody at all is known on the family tree. We can also step in and resolve missing particular branches of the family tree or find particular people where most of the family members are in touch, but maybe there's one side of the family that went off and everybody lost contact. We also trace missing legatees in testate scenarios. We can look for missing executors, freeholders, shareholders, and so on as needed. And increasingly, we brought in to verify existing family trees as part of the due diligence undertaken by practitioners. Sometimes this depends on the firm and the culture, but I think we're seeing an increasingly risk-averse situation here where practitioners are looking to protect themselves and make absolutely sure that the information they've been given is in fact correct. So they may be in touch with everyone, but they're just looking to be sure. And off the back of that research, we can offer insurance. I'll come back to that in just a moment. In terms of potentially bona vacantia estates, as I'm sure you will know, most are not actually bona vacantia, and there is usually some distant family member that can be found. So there isn't any need to involve the government legal department, which does very, very little on these estates except essentially advertise them. We can step in and we can locate heirs and help you to secure potential further administration work by doing so. So we do that at our own risk, and we work on what we call a contingency method. So coming to that method of payment, we can have this work paid for in a variety of ways, and we're always able to offer as many options as possible in any given situation, from a budget to a fixed fee to the ever popular contingency option, which is where a percentage commission is agreed with the heirs and then it's ultimately paid from their individual shares at the point of distribution of the estate. We have a legal support services team that offers specialist risk management support in particular areas. So, for example, one of the services that we work on all the time is a missing will search service. And this is very old school. We send out letters because we find that this gets the best response rates. And having done a missing will search, whether that's to confirm that you have the most recent one or that there isn't one or none could be found, we can then get insurance off the back of that because we're a tied agent for the insurer Aviva. Again, I'll be coming back to that in a second. Other services that the legal support team undertakes are searches for overseas beneficiary bankruptcy records prior to interim or final distributions, and a missing document service for documenting those specific events for which you don't necessarily need a full research budget. If we can do it within that more fixed and low cost missing document search service, we will do. So I mentioned that we're a tied agent for the insurer Aviva, and that gives us very quick, immediate ability to offer cover in a variety of situations, from covering a missing will search and confirming that we've done everything we can to make sure that no additional will has turned up, from missing beneficiary insurance for an individual or individual beneficiaries, to comfort cover over an entire family. So that's, for example, where we've done verification work on a family tree, and we've done everything we can, and we can then get cover on the whole estate. Coming in just the last moment or two to the service that I run, which is international assets. So this is primarily offered to private client practitioners where they need assistance with problem assets overseas. We could be talking here about helping to sell foreign listed shares, closing bank accounts, and liquidating and closing down investment portfolios that are based overseas. The work is often, but certainly not limited to, involving the USA. I think it's counterintuitively difficult in the US, partly because they have a different culture. They have extremely strict privacy and security rules in place, especially when the death of an asset holder has taken place. And what we tend to find is that practitioners who are perhaps time poor or don't have experience in this area might want some help to get these assets dealt with. There's a variety of reasons why they become problematic, from the financial institutions being unresponsive and difficult to deal with, overcoming security hurdles, legal hurdles, such as getting foreign grants of probate, for example, or resealing in Commonwealth countries. We can deal with a whole variety of these things. It's a very broad area, but a lot of this work, as I say, is in the US, but also in a lot of other countries worldwide. We work in Hong Kong, Singapore, Australia, and more. We help with the red tape. We'll engage our legal partners to do any of the legal work that's necessary in these foreign jurisdictions and bring the value of those assets back into the estate. I've worked in this particular field for about 16 years, so I have a wealth of experience that we bring to bear to problem solve throughout the course of a piece of work like this. That's it for me. I hope that this has given a flavour of the services that we can undertake for you. You can find out lots more about what we do online. We have a chat function on our website if you want some quick answers about what we can do for you, or you can call us or email us. We're always happy to talk about a case in confidence and with no obligation. That's it from me. Thank you very much for listening, and I hope you enjoy the rest of the webinar. Thanks.
Thank you, Louise. So much of that resonates, and actually just the verification of family trees is always something that's really useful and has in the past thrown up a few surprises. The clients don't always understand fully the benefit of verifying a family tree, and it has, as I said, thrown up some surprises and potentially has impacted the distribution of the estate. So really, really helpful. It's my pleasure to introduce someone who is reasonably well known to me, Gareth Ledsham, my fellow colleague and partner at Russell Cooke. Gareth and I have a number of cases on together, and really resonates as well in terms of managing difficult family dynamics in terms of some of the cases that we have on at the present time. Gareth's background is he is, as I said, a partner in our trusts and estates dispute team at Russell Cooke. Gareth has a particular interest and specialism in dealing with estates with cross-border element and particular civil law jurisdictions. Gareth acts for both claimants and defendants in 75 Act claims and claims for claims regarding breach of trust and proprietary estoppel. Gareth also has particular expertise and background in mental capacity and contentious court protection matters. Gareth, over to you and welcome.
Thank you very much, Kieran, and good afternoon, everybody, and welcome to this talk on the impact of family dynamics in the context of estate administration and probate. And thank you also very much to Surrey Law Society for inviting me to talk to you this afternoon. I'm going to be working on the basis that the majority, if not all, of members of the audience are people who practice estate administration on a regular basis, and I expect there's going to be varying levels of experience in that some of you will have been doing it for longer than others. And I'm also well aware that many of you will have dealt with various interesting characters, if I can put it like that, in the past. So I hope that what I'm going to say today isn't going to be sort of the proverbial teaching grandmothers to suck eggs. So really what I wanted to do today was to sort of give a bit of a reminder of the issues that can sometimes arise and how we might deal with them, how we might avoid them, and just a few examples of things that I've come across in my own practice. I was going to say just a couple of things about me, but Kieran has already really said it. But as he said, yeah, I'm a partner here at Russell Cooke, and I've been specialising in contentious trusts and probate matters, such as will challenges and administration disputes. I'm seeing quite a lot of those at the moment, and I've been doing that for getting on for about 15 years. And the other element of my practice is contentious court of protection proceedings, which is very similar. It's just that the people involved are all alive. I often joke that my practice area can be summarized as wicked stepmothers and squabbling siblings, although I obviously put a disclaimer that other delightful stepmothers and harmonious siblings are available. And I've said that for many, many years. And so when I was asked to give this talk on family dynamics, I thought it was quite apposite, really, because family dynamics really affects so much of what I do in my day-to-day job. And it's actually one of the reasons I really enjoy this area of law. I mean, the geeky lawyer in me does like the techie side of the law and sort of trying to come up with solutions to what can be quite tricky problems. But the other thing I really like about it is you get some really interesting people stories, sometimes some difficult people stories, but interesting nonetheless. And it's actually sort of quite a privilege to see into people's lives and help them to get to a resolution of what can be a very difficult time for them. So what I'm going to talk about today, I mean, I could go on all day about sort of family dynamics. So I've tried to sort of apply some sort of structure to it. The first thing I'm going to talk about is just a little bit of background and context. We're then going to talk about mitigating problems, so trying to avoid family dynamic problems before they arise. I'm going to talk about a few practical examples and how they could be dealt with, and then looking finally at how you as practitioners can protect your own position as a legal advisor. In my experience, there are plenty of pitfalls for the unwary, which can trip you up, particularly when you're in the heat of the moment of dealing with families where emotions are running high. The aim of the session really is to be as practical as I can be. So if you were coming hoping for lots and lots of case law, I'm afraid you're going to be disappointed. It's also a bit difficult to know where to start with family dynamics because it means so many things. So I think a lot of what I am going to say is going to be quite anecdotal based on my own experience. I am very happy to take questions, probably easiest if I deal with them at the end, but if there's a burning question as we go through, then I'm sort of happy to deal with that if it fits in. And as Kieran has already set out, there is the chat function Q&A to put those questions in as we go along. I do really think that this is a topic that lends itself to discussion, and I'm hoping that what I say today will sort of raise issues that you would like to discuss. And so I'm hoping that there will be some questions at the end and we can sort of talk about other people's experience of dealing with the various family dynamics that we all come across in practice and how together we can work out how best to deal with those. So just moving on to background and a bit of context, really. So I thought I'd start off with a few numbers. I was doing a bit of research recently into where we stand with people who have been diagnosed with dementia. And according to the Alzheimer's Research UK Dementia Statistics Hub, at the moment, there are 944,000 people estimated to be living with dementia in the UK, which is predicted to be over 1 million by 2030 and 1.6 million by 2050. Interestingly, I did find a suggestion that actually the numbers of diagnoses are falling, but the prevalence of it is rising because there are so many more people who are living longer. So yes, lots of people with potential capacity issues. The other statistic I had a look into was rates of divorce. And we can see that there's been a 9.6% increase in divorce rates from 2020 to 2021, according to the Office of National Statistics. And there has also been a 47% increase in probate disputes, according to the MOJ. And the most recent statistics I could get were only 2018 to 2019. However, in addition to that, law firm IBB Law back in 2022, last year, did their own report. What they did was interviewed about 1,000 people as to what their experiences of what their experiences were of probate disputes, and that seems to back up the statistics from a few years ago at the MOJ, in that they are definitely on the increase. And I think perhaps one of the surprising statistics that came out of it was about 3 out of 4 people they surmised from the research they did are likely to be involved in some sort of probate dispute at some point during their lives, and that mostly these were between siblings. Certainly based on my own practice and administration disputes in particular, I am seeing a lot of siblings arguing amongst themselves as to how estates are to be administered. So why am I giving you these numbers? Well, the reason is that they tell half a story. They give us facts about there are plenty of things for people to argue about. Capacity disputes are nothing new, and certainly they continue to form a large part of my day-to-day caseload, both in the court of protection arena and also in relation to contested wills and probate. The divorce statistics just go to show and evidence the fact that second, even third relationships are on the increase. For every divorce, a lot of these people do go on and have second or third relationships. That creates levels of families, so stepchildren from different generations. There's a matter I'm dealing with at the moment where a deceased had 3 different partners and children from each of those relationships. And I'm currently advising on how to resolve a trust dispute that's arisen out of that, and dealing with lots of family dynamics that arise from it. So as I said, they sort of tell half a story in that they give us facts that things give rise to factual scenarios that people can argue about. The other half of that story, of course, is how people react to them, and that's where the family dynamics come into it. Now, what I've seen over the past 15, I suppose, years of doing this, various examples of the sort of things that come up. And I think it's useful just almost to list them, because while you're actually dealing with it, if you're in the sort of thick of a matter, it's not always that obvious. But the sort of things that I see a lot of at the moment are sibling rivalry. There's a lot of perceived unfairness amongst siblings, not in every case, but certainly the ones that end up on my desk. And this can be a difficult one to deal with, because what's fair is obviously very subjective. A common example is where you've got a child who's cared for a parent, and they believe that because they've provided that care, then they are entitled to more of an estate than another sibling, whereas the parent in their will may have thought otherwise. I've also found that people have quite interesting ideas about what they're entitled to receive from the state. It's not that uncommon for people to contact me about challenging a will before the person who has apparently disinherited them has even died. The other thing I see in sibling rivalry cases is that there's often some sort of childhood trauma that comes to the surface, and it's unbelievable the things that sort of come out in the context of a probate dispute that has been obviously troubling someone for years and years and years, and then suddenly it all comes out into the open. But these things can be quite helpful to managing these disputes and these dynamics, because often the way to unlock an issue is to find something that doesn't actually matter to many of the participants in the factual scenario, but does matter to that one person. I dealt with a case a few years ago where there was a will dispute, and it was very firmly defended. But we were able to settle it by, what the main issue was it was a sibling dispute. The sibling who we were against could not stand the idea of his sister, my client, receiving any of the estate, which we said he had unduly influenced to be directed in his favour. But when the solution was to give it to the siblings' nephews and nieces, so my client's children, and suddenly the whole thing was unlocked. And this was all down to something that had happened in the sibling's childhood, but so he couldn't stand his sister, but the nephew and nieces were fine. So it's always wise to be looking at ways to unblock things. The other area of difficult family dynamics I often come across is perceived favoritism. And we can talk about how we can deal with this in the next section. But the classic example of this is where one sibling is named in a parent's will and one or other siblings are not. And this tends to lead to all sorts of problems. Related to that is the people who are named as executor can let the power go to their heads somewhat. And I think when you're dealing with this as estate practitioners, it's very important to be mindful to this. I think a lot of what I want to say today is about not taking what clients say to you at face value. It's very easy to sort of go along with what the client is saying, but I think one of the things I would keep saying is take a step back. Where are they coming from? Why are they saying this? Another family dynamic that can create difficulties is substance misuse. This can be proven or just alleged, but it does tend to give rise to difficulties in administering the estate, getting cooperation from people who may have received gifts, etc. There are potential capacity issues that you need to deal with, which need to be dealt with sensitively. And you may find that you've got a trust situation where a person who is either incapacitated or who is vulnerable by reason of the fact that they have a history of substance misuse, they've had their share of the estate left in trust. However, you can appreciate that this isn't all going to go down particularly well when they see their siblings get their shares outright. The person who's vulnerable doesn't get their share. And so there are difficulties in managing that because they are not happy about it. What does the executor or trustee do? Do we give in to them? Do we not? How do you deal with the anger issues that can come from that? So we've talked a lot about siblings and the arguments that they may have with each other. The other thing to be mindful of is difficult relationships with a step parent. And these can arise in particularly pretty unexpected places. Even if people have got on well, definitely no surprise to any of you that death can sometimes bring out the worst in people, and you can find that step parents or stepchildren suddenly have a massive falling out. And this often happens, no, not exclusively, if there is a younger spouse who is on the scene. I think it pays for practitioners to really, again, take a step back. It's very easy to get caught up in the emotion that is being presented to you as the lawyer. But think about, where is this coming from? You may have a step parent who is feeling extremely vulnerable or threatened, particularly where the matrimonial home is concerned. Likewise, you can have stepchildren feeling the same, and there can be all sorts of psychological issues that have arisen from the fact that, you know, one of their parents has had a second or third relationship. And often things can be born or put down to misunderstandings. So again, taking a step back, what can we do to smooth waters? Family dynamics don't always boil down to sort of relationships falling apart necessarily. Sometimes it can just be about people's different views on things. There are numerous occasions where I've come across different views about what should happen to a property. Should it be done up for sale before it's sold, or should it be sold as it is? People have different ideas about what's going to enhance value. I had one case a few years ago where one of the was the executor, who was a sibling, and my client was a sibling who was an executor, insisted on installing gold taps in the property, which seemed to be a massive bone of contention, and huge arguments and huge amounts of fees arguing about whether the gold taps actually added value or not. Those disputes, if you can avoid them, need to be addressed. The other thing to bear in mind when dealing with families in the probate process is that people are often irrational. People are often grieving. If there's a dispute in the offing, they could be sort of contemplating litigation. This is not a good combination, but it goes back to what I was saying a moment ago. The real key here is, don't take everything your client says at face value. Take a step back, look at it objectively. Where are they coming from? And then how do we approach it? There's often lots of misunderstanding as well. This is coming back to sort of the perceived fairness approach, as a point I made a few moments ago, about what the law is and what they consider to be a just outcome. So there's going to be a lot of managing expectations that arises out of that, what we're hearing from a disappointed beneficiary. A lot of it is about explaining what realistically the law does say, and also acknowledging that they may not find it very fair, but again, taking a step back, but equally being also mindful of your own position as the practitioner, because you can end up in hot water, as we'll come on to later on, if you end up being perceived as taking sides. So having looked at sort of the different family dynamic situations that can arise, let's have a look now at mitigating these issues before they arise. Before we look at that, there are two things that we need to think about. One, is this a pre-death or a post-death scenario? And secondly, what is your role as the lawyer? So if we're looking at a pre-death situation, in some ways, this is a golden opportunity for the practitioner to be able to give a reality check on what could go wrong and take the opportunity to ensure, as far as possible and as far as clients will let them, what the stakes are here. So as you will all be aware, clients will often come with very firm ideas about the state of their families and family relationships. What I would always say is, any client, and I'm sure this is your experiences as well, any client that comes to you and says, oh, don't worry, there won't be any arguments, well, that's automatically a red flag. For me, I've seen so many attendance notes from the files of lawyers who've been giving estate planning advice of an estate, which then ends up in litigation. And you can see that the solicitor has taken instructions and said, and, they may have touched on, oh, are there any family issues? And the testator says, oh, no, it's all going to be fine. And then, of course, someone like me's got involved because it really isn't fine. So I think it is really worth speaking to clients in detail about family dynamics and not just taking the client's views on this at face value. It really can pay to probe a little deeper into matters. So the sorts of things I'm thinking about here are, if you are taking instructions for a will, say, and let's say one sibling has brought the parent along to the meeting, but there are other siblings in existence, really useful to probe the relationship. Why has that sibling been brought along? What about the other siblings? What's the relationship like with the siblings? If there is a second relationship, what's the relationship like between the step parent and the siblings, and vice versa? And really getting into the detail of it, and try not to be fobbed off by people saying, well, it's none of your business. I mean, ultimately, if the client doesn't give you the information, they don't give you the information, and that's where sort of laying it down on the line as to what the consequences of that might be is the best thing you can do. But anything you can do to have a detailed attention of what these issues are can help you give advice on what the appropriate estate planning is likely to be. I suppose the other thing to bear in mind about that as well is that if you're looking at all these family relationships and potential dynamics, then this goes beyond avoiding a dispute, because what you could also be doing is acting as the first line of defense against financial abuse. Having looked at what family dynamics already exist within the family and really probed that as much as you can, really important to look for red flags, which I'm sure you all do anyway. But the sort of red flags I look for are there any capacity issues? Is there evidence or other instructions of a sibling or a family member being excluded or sidelined in some way? If that's the case, what's the reason for that? I've seen attendance notes where they say, oh, I'm going to exclude my daughter so-and-so because I haven't seen them very often. Well, that's all well and good, but is that actually the case? Is that a capacitous instruction? Who's told you that they haven't seen them very often? Is that the testator's instruction? Is that somebody, the sibling who's brought them along? The other thing to be aware of are there any psychological issues? It's worth, as I mentioned before, exploring, even if only to dismiss it. Are there any substance abuse issues that you need to be aware of? Second or third relationships and marriages we've spoken about, obviously not an issue per se, but again, need to look for strained relationships with children. If not now, could there be? Have these been discussed? Then once you have established that there are issues to deal with, that is the time when we start considering what evasive action you may be able to take. So the first one is probably quite obvious to most of you, is that if you are any concerns about capacity whatsoever, detailed attendance notes as always, but also get a decent capacity report. Even now, I still see capacity reports which are a one-liner from the GP saying, Mr. X has capacity to make a will, or sometimes, Mrs. Y has capacity. Capacity to do what is not exactly clear. So the report you get is only going to be as good as the letter of instruction that you send. And if you get a one-line confirmation back from the GP or whoever, do not accept it. The other thing that people don't always do with instructions to a capacity expert is give the level of detail needed to enable a thorough assessment to be carried out. If you are aware of family dynamics, difficult relationships, etc., it's important to set those details out to the the person carrying out the capacity assessment, because that is something that they can probe as part of their own assessment. The other advice I would give in mitigating things going wrong pre-death is really encourage honest communication with potential beneficiaries. I can't count the number of times warring parties have claimed that, you know, deceased said X, Y, Z to them, and then the other party says, well, no, they said this, that, and the other to them. The fact of the matter is yes, he, and it often is a man, though not exclusively, has told them what they want to hear, and that is just a recipe for disaster. So, really important to stress to clients, I think, that they need to have this honest communication with beneficiaries to the extent that they can. I mean, not everybody will want to do it, but I think it is worth pointing out to them that, you know, the alternative is that they're going to bequeath a probate dispute and the cost of that. And I'm sure it won't come as a surprise to any of you to hear that the costs of a single party in a probate dispute can easily reach 6 figures if these matters go to trial. Something else to think about in avoiding family problems further down the line is thinking about executors. Is one sibling proposed to the exclusion of others? If so, why? Is it wise to think about a professional executor in these circumstances? That's going to come into cost, but it could be money well spent if it avoids litigation further down the line. Alternatively, are there any other sensible representatives from different branches of the family thinking about, you may have stepchildren from one relationship and a spouse, and another child from a second relationship. Is it wise to have somebody from both sides who get on reasonably well to be appointed together? But certainly thinking about the professional representative, if you see trouble, and somebody who can appear objective and neutral, even if alternative family members could be, is certainly worth considering. And something else to think about is, are there any friendly litigators? We do exist, who you can use as a sounding board. I find more and more of my role is a risk management one. So as well as dealing with these issues when they arise and dealing with disputes when they arise, I'm often consulted by colleagues at the estate planning stage. It might be about a capacity concern, it might be about how one sibling is behaving, how what they're saying about other siblings and how that needs to be dealt with. And it's well worth just discussing with colleagues what potential risks there are, because then even if a client turns around and says, no, this is my instruction, this is what I'm going to do, at least they do it from an informed position, and you've protected yourself in terms of any claims later. Post-death is also an opportunity to mitigate family dynamics issues. Again, things that you need to consider are, first of all, consider what capacity you're acting for and who you're acting for, or acing for, as I seem to put on my slide. If you're acting either as the executor or for the executor, then I think it's very important to lay down communication ground rules or a communication protocol at the outset of a matter. Generally, and this is something that we'll come on to a little bit later, there is going to be no confidentiality between parties. So beneficiaries, there'll obviously be confidentiality between your executor client and you as the lawyer. But if you are instructed by several executors, for example, then there's going to be no confidentiality as between them and you, which is not something that people often realize. Beneficiaries, they may begrudgingly accept that one sibling is going to be the executor and let them get on with it. But when are they going to be updated on matters? How frequently? Really important to set those expectations at the beginning while emotions are running high. try and smooth the waters, and then obviously stick to it. And then I think the other thing that you can do is, take time to offer reassurance about what your role is as the solicitor to an executor, and that of your client. People are often suspicious about not being told things, or not being told things as quickly as they would like. If you can offer reassurance as to the fact that your role is really just to administer the estate, then you can hopefully deal with difficult families before they arise. I'm just thinking of an example I dealt with recently. I was consulted by a lady who was a joint executor but really did not trust her siblings, and they wanted to instruct one lawyer. She wanted to instruct another lawyer. She didn't know whether she needed to instruct me as beneficiary. And what I persuaded her to do was, just go to a meeting with the siblings and go to a lawyer and see what comes of it, see if you can get on. And given that I haven't heard back from her, I'm hoping that sense has prevailed on that one, and that the solicitor was able to explain what's going to happen and just calm down the sort of concerns that were being raised, which were perhaps understandable in the sort of light of the death, but looked at objectively were perhaps not as likely to occur as the potential client thought. I saw on the flyer that advertised this talk there were various examples of things that you were going to be told how to deal with. And I thought, well, they're on there, I better actually comment on those briefly. But it sort of shows family dynamics in action and how to deal with the particular issue that's in question. So the first of those was dealing with a group of siblings where you've got one of the siblings living in the property who had been living with a parent at the date of death, and how you get them out. This is actually potentially quite a tricky issue. First of all, obviously going to depend on the will, if there is one, and the rights that arise under it. If there isn't, then they don't have any rights per se. But before you go in all gung ho and say, okay, well, we need to get them out, then definitely worth consulting with the other beneficiaries. Depending on the family relationships, they may be happy for them to stay. They may be happy to come to some sort of arrangement where they can stay for a short period of time. And again, encourage everybody to put it in writing so that there can be no, well, there may be an argument, but there can be less of an argument later on. Again, think about the person that you're dealing with. What sort of personality have they got? Are they somebody who's potentially vulnerable? Consider a softly approach with them, and empathy is going to be important. Other thing to bear in mind as well, of course, that they've been living with a parent at the date of death. Have they got a Inheritance Act claim? Now, I say you need to think of this, but you also need to be quite careful, because it goes back to think about what your role is. If you're acting for an executor, you're not advising, presumably, as beneficiary, and a 1975 Act claim is a claim for beneficiaries. Likewise, you don't particularly want to be inviting claims against an estate, and so they might have a 75 Act claim, not one that you would mention to the beneficiary, but one that is going to inform your approach in depending on how you deal with it. Now, it may be that you can come to an accommodation and that the sibling moves out of the property in due course and the property can be sold. It may be that they don't. It may be that you do need to take, or the executor needs to take action to get possession of the property. But by taking the approach that I've just outlined, so taking a very reasonable, softly approach, is all about laying down a reasonable looking paper trail. Something I always say to trainees who do a seat in probate litigation is think about, or I suppose any litigation, is always think that this letter is going to be read by a judge. And certainly if you are going to be asking a judge to remove somebody from a property, if you can show that you've been behaving reasonably and taking account of the person's circumstances, etc., that's going to put you in good stead. Something else to bear in mind as well is thinking about your own client. So yes, they may be the executor, and yes, they may be keen to get a person out of the property, but what's their motivation for that? Have they got a stake in the property? I think it's just important to be mindful that if your executor client is also a beneficiary, have they got are they allowing their beneficiary instincts, they want their money, they want it now, to override their executor obligations? Of course, there's going to be overlap, but their obligation as an executor to make sure that they don't incur costs necessarily for the estate, for instance, and that they have the best chance possible of getting the property available for the estate. Moving on to the second example, that was disclosing a will that you know will be unpopular. So you've received a will and you look at it and think, oh dear, sibling X is not going to be very happy with this. Do we disclose it now, or do we disclose it after the grant? Now, in my view, this one is actually fairly straightforward. As everyone will know, a will is confidential until it is admitted to probate, and the temptation of some clients is to hold to this principle because I don't know why they insist on holding to it. Sometimes I think it's they have the power of withholding information. Now, of course, every case is going to turn on its own facts, but generally, I always advise that you should consider disclosing a will to a disappointed or likely disappointed beneficiary as soon as possible, unless there's a really good reason not to. And the reason for that is secrecy begets suspicion, and it's going to make the possibly inevitable dispute hard to handle. It's far better, I think, to lance the boil and get them to go and take their own advice at an early stage, rather than just let them work themselves up even further because you're not giving them information. And then suddenly when they do get the will, what could be a relatively straightforward matter to resolve between all the beneficiaries is suddenly blown out of all proportion because they've already worked up in their own head that the neutral executor is against them. Coming on to the third examples of dealing with two or more executor clients who do not get on, something that we come across all too frequently. I deal with this a little bit more in the final section, but key point, and it seems obvious, but I make the point because I've seen it so often ignored, is do not take sides. And it can be easily done. It's very easy to sometimes get caught up in what one client's saying, what the other client's saying. And occasionally you will have a situation where one client is blatantly more reasonable than the other. And it's very easy to sort of go, well, obviously they're being sensible, they're wanting to get the estate administration progressed and the other person isn't cooperating. But remember, both your clients, so taking sides is not going to be a good idea. So I think in this situation, this is one where you will wish to strike a balance between guiding them to an agreement in a way you're sort of acting a little bit like a mediator. So you're trying to see things from different perspectives and get the other to each party to see things from the other's perspective. But the other thing that I think is really important to bear in mind in this is that it's like a mediator, you can't prescribe a solution, and always have at the back of your mind as a practitioner that you may need to take a step back at some point and advise them to get their own separate advice. One thing I think you can probably do is set out in broad terms what can happen if they cannot agree. So this isn't obviously giving advice to either of them as to what they can do to move it forward, but you can set out consequences. So you can set out, for example, that the estate cannot, or estate administration cannot progress, that the court may need to intervene if they can't come to an agreement, that the likely result of that is going to be more costs, and essentially that your hands are going to be tied until they can actually come to an agreement. Coming on to balancing the interests of live tenants and remainder beneficiaries. Again, on this one, family dynamics can be an issue, particularly if there is a difficult relationship between stepchildren and a second spouse, which is often where one comes across these situations, I think you need to take care and again think about what role are you acting in. Are you a trustee yourself? Are you just advising the trustee? Is the trustee also a beneficiary? Are they a remainder beneficiary? Obviously, it's the duty of the trustee to carry out the balancing act, and all you can do really is advise them on what their obligations are to balance the interests of a live tenant. That they can't just go and put all the estate in assets which are going to have huge capital appreciation but no income, and just be aware of their of their obligations as trustee and as remainderman, and make sure that they are considering things properly as a trustee and not being swayed by their role as beneficiary. Okay, finally, and I can see we're actually coming up to sort of 1:30. I wanted to talk about protecting your own position as an advisor. So this section is a bit more about things to think about if problems do arise, but not from your client's point of view, but from your point of view. And as we all know, where clients are concerned, you can take the horse to water, you certainly can't always make it drink. And again, I apologize if what I'm about to say sounds obvious to everybody, but self-evidence is often overlooked. It's only seen if something's looked at objectively or with the benefit of hindsight. And one thing I have seen, unfortunately, in my career is cases where probate practitioners have lost sight of their role when feelings are running high. For example, I mentioned before, when you've got two executor clients who aren't getting on, then it can be possible that you might give in to confirmation bias because they're confirming what you know to be the proper way to go forward, and what a reasonable executor should be doing in those circumstances. But you still have obligations to the to the other client. So again, I come back to who are you acting for and in what capacity. I've come across so many lawyers who write to me, and it's just not clear who they're or what role they're actually playing, and they've got themselves confused. Often, if you're a non-contentious practitioner, you're going to be acting for clients in their role as personal representative, but they could also be a beneficiary. And I think it's quite important, well, it's very important, in fact, that you define your retainer carefully, and make sure that you are setting out what advice relates to their role as personal representative and whether you're even going to give them advice as a beneficiary. But if you're not retained to give advice to them as a beneficiary, then be careful not to do so, and beware of mission creep. The other thing that often arises is conflicts of interest. Everyone knows what a conflict of interest is, and if you can't act for two parties to the same dispute, for example. But what people are sometimes less mindful of, because they're less obvious, are own interest conflicts. So have a think about what advice you gave to whom during the deceased lifetime. Did you draft the will? Have you got information that you wouldn't be able to give to your own client because of your duty of confidentiality to another party? If so, if you've got information that would be relevant to that client in advising on their position, which you can't give to them, then you have an own interest conflict. You shouldn't act. I often see it as well in 1975 Act claims. Executors or administrators can start taking quite a lead role in trying to sort things out, when that really isn't their role. Executors and administrators are generally neutral to a 1975 Act claim. They might be a beneficiary of the estate, or they might have a claim themselves, but that needs to be separated out from their role as executor, which is really just to provide information. Again, if you're communicating with the parties about that, really important to be clear on what basis you are acting for them. And particularly if you've got a 1975 Act claim and that goes to court, you need to have separated out the costs that you incur for the client as administrator or as executor from those that they incur defending their position as a beneficiary. Again, laying down ground rules of clients at the start and managing expectations. This comes down to I think really the confidentiality point that I mentioned earlier. If you are acting for more than one client and they start to get a little bit fractious with one another, then so important to make sure that when the client phones you up and starts moaning about their co-executor, that you cut that conversation short and explain that before you go on, anything you tell me, I can say to, or I'm duty bound to say to the other client, the other executor, for example. And so often will be the case that there'll be a falling out. You end up ceasing acting. The file has to be transferred to another lawyer. And if you've got evidence on there, be it in emails or attendance notes of one client bad mouthing the other, and there's any hint that you have not been anything other than I can't enter into this, then you're setting yourself up for difficulties further down the line. Which I suppose leads me on to the need to take a step back and always be alive to the fact that parties may need to take their own separate advice. This runs slightly counter to what I was saying earlier, because there is an element of nobody wants somebody to have to go and instruct other lawyers and incur the costs of doing that. But in order to avoid that, there may be an element of sort of acting a little bit like a middleman, a little bit like a mediator. But if you're going to do that, and I think that's great if you can get the parties to see sense and move forward, just be aware that there are going to be some clients that you're not going to be able to do that with. And at that point, that's the time to step back, tell them to take their separate advice, and then you can sort of down tools until they either come to an agreement or the court intervenes. Generally, in my experience, you're going to end up with an independent administrator at that point. And then my final point is don't rise to provocation, which again you would think sounds obvious, but I can think of numerous rather ill-advised, should I say, emails that I have seen written by lawyers to beneficiaries who I can understand why they've written in the terms that they have, because objectively speaking, the language, etc., of the beneficiary who is very upset about any number of things is provocative, but having that go in front of a judge is not a particularly great experience for the lawyer. And I have had emails from lawyers in front of a judge where the lawyer has been less than professional. It's just not a good look. Anyway, that's a very whistle-stop tour of sort of family dynamics and the issues that can arise, and a few hints, I hope, on how to deal with them. I can probably speak about it all day, and as I say, it's a very fact-specific area, but I can see that there are a couple of questions in the chat. I can't see what the questions are, but yeah, happy to deal with those.
Gareth, thank you. That was really, really insightful. I do have sight of the questions. So that the first question that we have is, how would you handle a case where the property in which a family member is residing has to be sold to pay IHT?
Well, you first have to look at whether the person who's residing in the property has any right to occupy or whatever under the will. And we'd also need to look at whether there are any other options other than selling the property. Is the person residing there, can they fund the IHT themselves? Is there a way of doing a variation of the estate? If not, then you're going to need to look at selling the property, and you're going to have to manage their exit from it.
Thank you, Gareth. And on a case, albeit the circumstances are slightly different, we are considering how we remove a partner that's occupying a property. One of the steps that we're considering making is making an interim payment to the partner who potentially has a 75 Act claim to incentivize her to remove herself from the property, and ultimately any further payments would also be paid to her strictly from the proceeds of sale of that property. So it's about, again, incentivizing the claimant or party with whom our clients are in dispute with in order to achieve the goal that we're working towards. I would also add, actually, just in relation to payment of IHT, up until about a year ago, interest rates were relatively benign with HMRC. We're now looking at interest rates of 6.75%. I'm working on a case at the moment where interest is an eye-watering, potentially £1,000 a day. So delays in terms of removing people from properties, whilst clearly that's in most cases will not be anything like £1,000 a day, can be expensive, and interest rates, as we're seeing, are accumulating on estates, and those numbers are getting large. So I think that's potentially something that we're going to see more and more of, and becoming an issue as interest rates filter through onto estates, particularly being with potential delays in probate applications as well. We have a second question. So firstly, Karen, thank you for commenting that it's been a superb presentation. That's always much appreciated. Karen's question is, how are...
I say that. Wait to hear the question first.
It's a good question. How are out-of-court dispute resolution processes used? ? Mediation, early neutral evaluation, etc.
A very good question indeed. I tend to use mediation mainly. It depends very much on the dynamic. It depends on the parties and how ingrained the dispute is. It also depends on the lawyers involved as well. I find that resolving a dispute, I mean, it's a small world in which we all operate, and I think the world in which contentious probate practitioners operate in is even smaller. So there are a number of lawyers who I come across on a fairly regular basis. If I have them on the other side and I've got a good relationship with them, then it may be that a few sensible phone calls can lead to a resolution, depending on what's involved. If not, then mediation is something I am a huge proponent of, because a mediator, especially a skilled mediator in this area, will be well versed in family dynamics. And the beauty of mediation is that you can come up with a solution that a court can't impose, but that actually takes account of the family dynamics. So as the matter I mentioned at the beginning of my presentation about the siblings who couldn't stand each other down to, I can't remember what it was, but some issue that had occurred in childhood. And then we were able to unlock it just by varying the estate, so that whatever settlement sum was just paid to my client's children, and the whole thing was resolved. So yeah, mediation definitely. Roundtable meetings, if it's wise to put people in the same room. I do find that in mediations, I tend to keep people apart, because they get together, they have a fight, they entrench their positions, and it doesn't help anybody. And it really is about the sort of objectivity and sort of helping them to get to a resolution and move on with their lives.
Gareth, thank you. Those are some really useful points. I think in particular about keeping parties separate during mediation helps to ensure that, as you say, positions do not become even more firmly entrenched, and allows scope for a mediator to do his or her work effectively. That brings us to a close for today's webinar. So thank you very much to everyone who has attended. Thank you to Louise Levine of Finders International for your continued support. That's always appreciated, and very welcome as we offer a CPD to our members. As I said earlier, the recording of today's webinar will be shared with you later this week. If there are any further questions, I'm sure Gareth will be very happy to answer those directly. And I don't know if your contact details are available on the slide, Gareth.
They are. There we go.
Great stuff. Thank you, Gareth. And once again, thank you to everyone who's attended. If there is any feedback that you'd like to provide, please contact Helen Opie at surreylawsociety.org.uk. That's Helen, HELEN .OPIE at surreylawsociety.org.uk. Gareth, nice to present a webinar together with you. We haven't done that before, so it's been enjoyable. Louise, thank you once again for your support, and thank you to all who have attended this afternoon. And don't hesitate to contact Gareth should you wish to put any further questions to him. Have a very pleasant afternoon. Thank you all.
Thank you, everyone. Bye for now.